All right, I think we're live. We are live. What's going on, everybody? Okay. Yes, sorry about the technical difficulty, but it seems like StreamYard doesn't like me for some reason. So it just kicked me off and then brought me back on. All right. So today we are reviewing the Rekieta case again. And I know people are like, you're reviewing a Rekieta case again. I'm like, yes, I'm reviewing a Rekieta case again. Because I think it's so fascinating. I got my boy Uncivil Law here who's going to be checking it out with us. Hey, good evening, good evening, good evening. No, this is not a boomer moment. This has been happening pretty much all day. After I upgraded Chrome, it just keeps kicking it off and bringing it back and kicking it off. So I have to deal with it a little bit tonight, but hopefully that will be the last one. I've heard no drugs belong to anyone else in the house. That was then when it got raided. I was trying them out so many times. I don't know. It seems like no one knows. Marco reality. Ownership of drugs sounds like a jury question. It does. But there is some technical issues there. So for those of you who know what's going on, Nick filed his omnibus motion, which was like a motion to dismiss, but really like a motion to eliminate. It's like a couple of motions that he kind of just like mushed together and just gave to the judge and was like, I want this evidence thrown out for multiple different reasons. We'll go over that. Then they had their hearing and they're going forward, right? They're going forward with the case. Nothing was dismissed. Then we had April. So let me bring up April's thing real quick so you guys can see what's going on with April. I got the X account here. So April, she was the co-defendant with Nick. Essentially, she was the one who was also in the house with the drugs. So here is what she filed, which was a motion to dismiss the complaint. And her main argument in this motion to dismiss was simple. Her argument was there were drugs in the house, but I had nothing to do with these drugs, right? I had absolutely nothing to do with these drugs. These drugs were in the house. They weren't mine. I just happened to be there. I was at a family barbecue. When these drugs were found, right? So, and the law, it's like this. Like, say if you go to a store and the store gets raided, there's drugs in the store, and you're a customer, they can't just take you because you're a customer. They have to have some reason to believe you were involved in the drug activity. So that's essentially what her motion here is trying to do. So she's asking the judge to dismiss her charges based on that. And you'll see that interplay between the district attorney and her. But let me bring in my guest, Uncivil Law. Uncivil, what's going on, brother?
Yeah, I'm fine. Yeah, good times.
Yeah, good time.
How are you?
I don't know. I'm doing all right. I'm fascinated by this case though. And I'm fascinated because on one end, like, to be fair, and just so everybody understands my biases here, I want Nick to get off. I hope he gets off, and I hope he gets help. Those are like my two the things I wish for the most, right? I don't want to do any jail time. I don't want to have the felony because having a felony that means he can't have any guns. They're like real world consequences to this. But you can have
can't vote, and plus in many states you have to disclose that when you apply for jobs, and makes it very difficult to get jobs. So it has a lot of collateral consequences.
So I'm hoping he can get out of this without any type of criminal record, but have a lesson learned. And that lesson would be like, hey, you got some issues, maybe get some help with abuse and drug abuse and that type of thing. So I am hoping that would be the best solution for this issue for me personally. But I know reality has got to set in, and and he's kind of got to go through the process. What about you? How do you feel about this whole thing?
Well, I mean, you found drugs in the house, so you presume that the logical presumption is that they're the people who belong to the house. I mean, that's logical. And we've seen nothing to contradict that. Plus, April apparently saying that they don't belong to her would seem to imply that they apply to the owners because, well, not a whole lot of other possibilities there. So, I think this probably ultimately resolves unless the charges change, which is also a distinct possibility because The lab came back with the results, as I understand it, because at the last omnibus hearing, there was a disclosure relating to the lab results. So I think the lab results are now back. So depending on what those lab results indicate, there's also the possibility of different charges or even elevated charges, depending on what other substances were found. But if that doesn't happen, then my expectation would be that this is going to resolve in some sort of plea deal or diversion program, would be what I would imagine. He has no other criminal history. He has some traffic infractions that don't really count for the purposes of that calculation. So I would think that he's a pretty good candidate for some sort of diversion or other reduced sentence or plea.
Yeah, I think all the Nick haters who he's going to jail for life and all that stuff. No,
Yeah,
the
even
25 years, even if he was convicted. Go ahead.
Yeah, on the sentencing guidelines in Minnesota, and we looked them up in my previous channel.
Yeah.
So for this offense with no criminal record, the sentencing guidelines recommend no prison time. They recommend, I believe it was 48 months, if memory serves correctly, suspended, and up to theoretically a year in jail. But you would expect no time.
Yeah.
So the charges as they exist right now, you're looking at no time, is the reasonable conclusion. But still a felony conviction, plus probation, of course, but still.
But yeah, you're not looking at any felony time. April on Zoom from Nick's basement was hilarious, which is true. Yeah, he's still he's in Nick's basement, and love the coverage, fellas. Thank you so much. Here's a quick question: silver lining, Rackets being a felon is that he will never actually try to get a real job. Oh. Well, listen, again, full disclosure, Nick is a friend. And I'm covering a story just like I would cover anybody else's story, and I would suppose he has covered my stories. Nick's covered like every time anything's happened, he's covered it. So, so we're just doing our due diligence. I think the story is fascinating and interesting, and I'll always like to delve into the legal arguments. So let's, so first let's get into the motion hearing here. So I'm gonna pull it up real quick. This is.
And also, while I'm thinking about it,
sorry, just to pull that up
because people will probably ask what this means for his license. This is not the first time the bar has had an interaction with someone with a potential drug issue. So my expectation is that any sanction by the bar would otherwise be fairly minimal. It probably some sort of, again, program, treatment, perhaps some sort of suspension, but almost certainly not a disbarment. You're not looking at really any sort of serious consequence, I would imagine.
Well, you could have maybe a suspension or something like that, or being forced to go into drug treatment or something like that.
Right.
That's the more logical thing, because people, it's not, and I think people fail to or forget to realize that the goal now, especially with drug offenses, is treatment and trying to help people recover from this, not this overhanded, not the overly harsh, go to jail forever, right? Because
especially in a state like Minnesota, which I would imagine, on all things being balanced, is probably more progressive in that dimension. So
yeah, definitely. So we know it, but now, instead of reading a document, because they already explained to you what it's going to be, let's just listen to the court. Now, I got this off the channel. Let me put this at the end, because I want to give the person whose channel I ripped this from. His name is Greg Edwards, but that's his symbol that if you type April emote and her and hearing, his channel will come up. So I'm just letting everybody know that's where I got this from. To give him a little shout out. Hopefully, I don't know the guy. I've never watched any of his stuff, but just to give him a shout that I actually got the video from there.
It does look a lot like Nick's basement.
You're charged with one count of possession of controlled substance, a felony violation of Minnesota statute section 152.025, subdivision 2, paragraph 1, and subdivision 4, paragraph B. Maximum penalty 5 years imprisonment, a $10,000 fine, or both. Ms. Imholt, you have the right to remain silent and not submit to police interrogation. Anything you say may be used against you in this or any subsequent proceeding. You have the right to counsel in all proceedings, including police lineups and interrogations. You have the right to be represented by an attorney of your own choosing at your own expense. However, if you demonstrate indigence, then attorney will be appointed at public expense.
Now, it's interesting because she was initially charged, then her charges were dropped, and now she's being charged again, right? That's essentially what happened, right?
Yep.
You have the right to communicate with defense counsel, and a continuance will be granted if necessary to permit this. You have the right to a trial before the court or a jury. Mr. Gallagher has submitted a certificate of representation. Mr. Gallagher, you've also submitted a motion to dismiss, and it's your motion.
Okay.
I think some of his
The defendant were found. And then it says, the fourth time it mentions her name, it says her purse was located in a hallway between the master bedroom leading to the attached bathroom. And that a co-defendant indicated, and the homeowner indicated that the defendant was at the home visiting at the time of the search warrant execution. Mere presence is not enough to support a possession charge. There's no allegation that she possessed any drugs. And so we're asking that the court dismiss the charge.
Now,
Fair.
I would say if you're a lawyer and you're representing a client in this case, this is exactly what you bring. I don't see now, even if it doesn't work, you have to bring this because she's a guest at someone else's house, you know, and that's the number one thing. This is the I walked into a store and it happened to get raided for drugs, right?
Mm-hmm.
Essentially, I didn't know any of the stuff was there. Yeah, my bag was near, but I wasn't there. So I think so. As a defense attorney, this is what you want to bring. You definitely should bring this motion. So even though I don't think it's going to work, but I think you need to bring it.
Ms. Pierce.
This is the ADA.
Your Honor, Ms. Imholt was found in the room where the drugs were found. She's only being charged with the drugs that were found immediately on top of her credit cards, which were active and not expired. One was a bank card, and her purse was found in the master bedroom suite, which between the master bedroom and the bathroom. And she was in the room when law enforcement executed the search warrant, and the drugs were out in the open on top of her immediate possessions, with the rest of the contents of her purse also in that room.
That sounds like probable cause to me. What do you think?
Well, as the defense counsel points out, merely being there isn't sufficient, but the fact that her credit cards are there and they're active cards, so she's presumably using them, and the drugs are on top of them, is much more suggestive to me.
And the fact that she's in the room with the drugs and her purse is in the room with the drugs too. It just, because don't forget, probable cause. People, I think this is important to for everybody to understand. Probable cause is a very low state. This is not beyond a reasonable doubt. She had to be using drugs. You just have to prove that it's reasonable to believe that she was attached to these drugs in some way, in some manner. You have a reasonable belief. And in this case, it seems like they're saying our reasonable belief, based on the evidence, is that her credit cards were literally under the drugs. She's in the room with the drugs, and her purse is also not with her, but in the room with the drugs, and the drugs were out in the open. So in a situation like that, would a reasonable person believe that she is involved in that drug activity? You know what I mean? What do you think, Kurt?
The only thing that's sort of pushing it over the top for me is the apparent fact that the drugs are found literally on top of the credit cards is the only thing that's pushing it over the top for me. Because otherwise, I wouldn't think it's enough for probable cause, even acknowledging that probable cause is a really low standard. Because again, it's like this issue of mere presence. If I come over to your house and you're my friend and I'm walking through your kitchen and I see drugs and I'm like, those are drugs, because I know they're drugs. And I just like am hanging out in your house, right? That's not enough. So the thing that's pushing it over the top, the thing that's doing it for me isn't that she was in the room. That doesn't really do that much for me. The purser's there. It's like, But the fact that her credit cards are out, that they're active cards, which means that she uses them. They're not, old cards that just are sitting around. And there's drugs literally on top of the cards is much more suggestive of possession. So I think that makes more sense for a probable cause.
But I do want to just make note that probable cause isn't a one thing type scenario. You have to kind of look
Sure.
at the whole picture. So that's the reason why I mentioned she's in the room, she's this, because when you're talking about probable cause, you are looking at the entire picture and saying, would a reasonable person look at this entire scenario with the fact that her active credit cards are under the drugs? Would a person believe that she's, and that's so I think that alone, like you're saying, would probably push me over the top. The others would without it. But if you look at the whole thing together, I do think you at least make probable cause. What do you think?
I would say that the fact that the credit cards are there with the drugs on them is necessary, but not sufficient. So if that element was missing, I would not say there's probable cause.
Correct.
I would say it's a necessary. I would say it is a necessary element in this equation.
It says they have been asking who won, who's the dealer. Couldn't that be part of a plea deal? It's I don't know what they're asking for in a plea deal, but I'm assuming with this particular case, they're going to be asking. It all depends on who you want. If they want Nick, they probably ask her to flip for Nick. But again, I know when I was a DA in New York, we're looking to help to put people in treatment because it's very progressive there. So we're not looking to put people in jail. So any deals would be like, hey, we want you to flip on this guy, but we're trying to make you flip on this guy to make it more likely that he'll take the treatment option, right? We're not trying to put him in jail. Like, why would you want to put Nick? He's got kids, he's got a family, he's got family. Why would we want to put him in jail for 5 years? That doesn't make any sense. It doesn't make any sense. But what makes sense is get him in treatment, make him a productive member of society, and make him move on with his life. And I think, and that's the way we handled it where we were at. But again, this is a different jurisdiction. So, but I'm assuming they're pretty progressive there too. So that, they may be looking for something like that. April has lived in their house for months. So that's another thing too. She was actually living in that house too. She wasn't just some random visitor.
Well, that isn't apparent on the probable cause.
Yeah.
So we obviously can't factor that into the equation.
Unless the police knew that before. If they didn't know that before, then you wouldn't be able to make it happen. All right. So let's go back to the
Well, mere presence is not enough. That does show that she was in the room and creates a joint possession that she was using or at least with one of the homeowners in that bedroom where the drugs were out in the open on top of literally on top of her property of her bank cards.
I do think it's hilarious that she's there while Nick is in Nick's office, right?
That seems like a very questionable choice on just a bunch of levels, but okay.
Oops. Yes, I don't know what she's doing.
For a guest, she does seem to be over there a lot. I have been over to your house a couple times, but I don't think I've been over to your house as many times as April's been over to their house. So might suggest a little bit more close relationship than you and I perhaps even have. Who knew that was possible?
For today's purposes, I'm denying the motion without prejudice. I think the motion is not as simple as the defense filing would make it seem, considering Ms. Pierce's take on the evidence, and that the motion to dismiss would be more appropriate for a Rule 11 motion where the parties could dive in a little deeper to present the court with the full flavor of the evidence. And so for today's purposes, it's denied. And Mr. Gallagher, would you like to combine Rule 5 and Rule 8 today?
Yes.
All right. Are you waiving reading of the complaint, deferring entry of a plea, and demanding an omnibus hearing?
Yes.
And are you wanting the contested omnibus hearing right away? Or do you want to be on the uncontested block first?
I think we'd rather be on the uncontested block because every now and then discovery issues pop up.
Yep, and that's fine. The purpose in our county for the uncontested omnibus is for the defendant to either demand or waive the contested omnibus. So it does buy you a little time, and then the case is not assigned yet either. We'll assign it once you demand or waive omnibus.
Thank you.
All right, so she's moving forward. They're going.
Well, I mean, that's standard. I mean,
Yeah.
that's fine. He wants to go through the steps and he wants to drag it out a little bit. Makes sense to me. So he wants to go on the uncontested omnibus, get some discovery, then go contested if they need to. Yeah, makes sense to me.
2:30? That's out of 14 days. Would be the 11th at 2:45.
We would waive any time
Oh,
limits, by the way.
gosh, I'm totally sorry. My fault.
Omnibus. Was
Okay, time is waived, so the 17th, a lot of our prosecutors are gone. And so
Okay.
let's go into,
October 8th at 3:30.
That works for the state, Your Honor.
That works for me. I'm not sure if my client, is that a good date? April?
Yes, Your Honor. Yes.
all right, 3:30 on October 8th. That continues to be a remote appearance for uncontested omnibus. Ms. Pierce, what's the state's position on release?
Your Honor, this does involve the possession of controlled substances. We are requesting unconditional bail in the amount of $20,000, conditionally that she could be released on her own recognizance on the conditions that she have no use of controlled substances or alcohol that are not prescribed, submit to random testing, remain law-abiding, and report to probation as directed.
Mr. Gallagher,
Your Honor, I believe the allegations are very scant in this case, to the point that it would be inappropriate to have conditions of release on her. She's here on a summons. I don't know why we need to impose bail or conditions, especially testing.
Ms. Imholt, you're ordered to make all future court appearances, arrive 15 minutes early, ready to proceed. Keep in contact with Mr. Gallagher as he's your point of contact for all court business. You are to be booked on this charge.
Oh, because all right, so they released her, then they charged her, so they haven't actually booked her in yet. So she's got to go and get fingerprinted and the whole thing.
Neat.
Yeah.
Okay.
So yeah, I would be annoyed too. People are like, she's annoyed. Yeah, she's annoyed because she's got to go through the process now.
How am I having a hearing on a criminal charge that I haven't even been booked on yet? That's a neat trick. Does the charge actually really exist?
He filed the motion to dismiss before she was booked.
Yeah, that's a new one.
And you'll need to make arrangements to come into the courthouse in
See?
Candiway County and Wilmer any business day from the hours of 9 to noon or 1 to 4. And that's just for pictures and fingerprints. If you've already done this, then that has been satisfied. You are ordered to remain absolutely law abiding. You may gain your unconditional release by posting cash or bond in the amount of $20,000. In the
Seems excessive.
alternative,
Well, this is because what she's being charged with a felony drug possession. So I'm
It's
thinking,
5th degree, and I agree with defense counsel. The evidence is kind of thin. $20,000 because bond bail is supposed to accomplish two objectives. We want you to show up, and we don't want you to hurt other people. Right? That's what we want you to do. Please come to future hearings. Please don't hurt anybody. So, there's no real indication at this time that she's really a threat to anybody else. So that doesn't really apply. And in terms of her compliance, she's shown no ill compliance. So
yeah,
$20,000 seems a bit excessive to my mind, but maybe I'm just feeling merciful today.
I think she's there. Well, even though you're right, I think she's there without even being charged. Right? She hasn't officially been booked yet.
Yeah, I know.
But I think, unfortunately, because a lot of the bail reform acts, the issue is that they would treat people in the suburbs differently than people in urban, or black people different than white people, or men different than women. So I think for this particular charge, it's like a standard bail, and they're just reading out the standard bail because again, you can get ROR, but it's ROR with conditions. So.
Yeah, I mean, I just would like to adjudicate every person under her own merits. To the best of my knowledge, she has no criminal history. She has no history of violence. She has shown up. It's a 5th degree. It's a little bit thin. So it's just like, I'm actually trying to provide individual justice. I'm sorry for, any disparities based on other issues, but it isn't fair that she gets screwed. She's entitled to her own constitutional rights. So
Listen,
I don't know.
I agree with you. I think
I'm going to defend April, man.
90% of the time, this would be an ROR. But I think because unfortunately they just have these probably it's like mandatory minimums. It's just like you have these mandatory. Okay, this is just a mandatory, and you do get ROR. So let's play it out.
I will release you on your own recognizance, subject to conditions. The conditions are as follows: don't leave the state of Minnesota without prior court approval. Have no use or possession of alcoholic beverages or mood-altering substances that are not prescribed to you, and submit to any form of testing to verify that you are abstaining. The testing can be at the demand of law enforcement or probation. You are responsible for the cost of the testing. Failure to cooperate or failure to show up for testing is the same as using and providing a positive sample. You'd have no use or possession of firearms, dangerous weapons, ammunition, or explosives. You must meet with Candy County Community Corrections initially to do intake for pretrial release monitoring of the court's conditions, and thereafter as they require. Their number is 320-231-6222, and you are required to call them and establish this relationship for pretrial release monitoring within the next 24 hours.
Those are some hell of a conditions, though. Not gonna lie. Those are a lot of conditions for ROR.
Yeah, sounds a little excessive.
Well, you can't. Well, again.
Well, there's one that there's one that there's one that I didn't hear that you'll sometimes hear as standard condition, which is no contact with anyone else relating to the case. No contact with either Nick or Kayla. You didn't hear that one. That'd be real. That'd be interesting and dynamic.
So 10% of 20K, 2K. Nick will pay it. Take my $5. Monday, gracias. Goose. All right. Well. What is yeah, it was just, yeah, she probably just have to pay the 10% to get the 20 grand. I'm not sure if it's a cash or bond situation now. I hope it's not. I hope it is a cash.
Oh, I'm sure it is. I'm sure it is.
All right. Anything else to come before the court today, Mr. Gallagher?
No, Your Honor. Thank you.
Ms. Pierce?
No, Your Honor. Thank you.
All right, so that seems to be about it for that. How do you think that went? Do you think? Well, I think their argument.
Paint by numbers, man. Paint by numbers. It's an initial appearance.
I think the argument you got to make. I think that it's the right argument to make. It's the argument I would have made. I would have fought a little bit harder on the credit card issue, but it's going to be hard because again, you got to attach the drugs.
Oh, apparently we missed the best part. Apparently there's more.
That's the best
part. More?
Let me see. But wait, there's more. All right.
There's trolls screaming.
Oh yeah, at the end. Trolls? At the end, yeah, there's some trolls screaming at the end. Hold on, I'll play the troll screaming so you guys can hear the troll screaming.
All right, matters adjourned. Thank you.
Show us how those tits are, April.
Lord.
Look at you, wow. you evil people wanted to hear the trolls.
Wow. Wow.
So if I'm the DA, the plan is
they need to find those people and put them in contempt. Make them wear a sandwich board outside the courthouse.
I don't freedom of speech. Mute the mic, mute everybody else's mic. But what I do think is that I think in this particular case, I think she has the best chance of getting out of these charges. It's not her house. Sure. She's just there. Now, her being the live-in nanny and she'll living there for a whole bunch of months, that could lead to more than, hey, you were just there, right? If you're there for months and there's drugs in the house and your credit card, then that now leads to probable cause. So I think you don't have probable cause maybe to arrest at the time, but then you may be able to develop it through more information. She should try for some PTI. She should try for a PTI program. What is PTI? Explain PTI to me. You know what PTI?
Pretrial intervention, I'm guessing.
Oh, maybe. Oh, all right. It's like a deferment program that we call them something different here. It's funny when I worked. Yeah. I'm civil lawyer. Your mic is too loud.
I
louder
turned it
than
down.
Nate's. Oh.
I send it down. I'll turn it down some more.
So-
The magic of StreamYard, trying to find the volume levels, man.
Yeah, I don't know what's up with StreamYard. So April, I think now in Nick's motion, he was concerned because allegedly April made some incriminating statements when she spoke with police.
Sure.
So, and Nick is trying to get those statements tossed. In other words, he doesn't want those statements used against him in his motion.
Yeah.
So that's going to be interesting because again, if she's living in his house and they have that, it's going to be a little issue.
But that's an issue for trial. We're not there yet.
Yeah, and I think that's isn't that what the judge said? He was like, that's
Yeah, that's what it says.
Yeah.
Like, this should be a motion to eliminate. This is not the right time. It's not.
Well,
It's
let's
like,
look
it doesn't
at.
belong here.
Well, now let's switch to. All right, so everybody knows what's been going on in the law tube space or the law influencer space, as we now know.
Are we? Oh yeah,
we're law law
as they
influencers.
covered the article. Yes, we're law influencers now. Apparently, that's good news.
So everybody understands. So it seems like there's all the law commentators who are trying to be reasonable with this, and there's Robert Barnes. Now, Robert Barnes. Now, I just want to be very clear. Robert Barnes wants us to lie to you, the audience. He wants us to lie to you. He wants us to tell you that the police had it out for Nick, the jury has it out for Nick, the judge has it out for Nick. He wants us to actively lie for you. So he throws a whole bunch of worthless arguments out there and pretends that they are meaningful. And when none of us, myself, Uncivil, anybody who's covering the case, we all say those arguments are going to hurt our credibility. They're nonsense and they don't make any sense. So instead of him understanding why, that's why we all went over his arguments. Like, none of these arguments make sense. They are stupid. Now, Barnes has a huge history of being dumb. Like, to be fair, all his predictions for all the cases are essentially wrong. Matter of fact, when he's right, Viva runs out and yells, Barnes is right, Barnes is right, Barnes is right, because he's right so few times.
Even a broken clock, baby.
So with that being said, but now I think Barnes is cool. I like Barnes. You know, he's Alex Jones' attorney. You know, matter of fact, if you
I don't like him. He's a bad legal educator. He says
I don't
things that are
he doesn't
I don't like
he's not an educator. He's a propagandist. He's there to make you he's not a legal educator. He's there to literally place narratives, right? Like, for instance, remember Barnes was the one that said Biden will never drop out of the presidential race, right? Nobody held up a sign saying Barnes was right about that, right? So unfortunately, that's the way Barnes is. And I think you're right. I think I don't think he does legal education. He runs narratives. And because we weren't running in narratives like Legal Mindset, poor Legal Mindset, he's essentially calling him a pedo, right? He's saying bad things about me, saying bad things about things about all of us.
Please don't call each other pedos. We've learned that from Nick. Okay, can we learn from the misfortunes of others, as I say on my channel, and not call each other pedos? That'd be great.
Yes. So and it's sad because, you know, he's lost a lot of respect from his own crowd because he's doing things like that. But I will say this, you know, whatever happens with Barnes and Viva, that's one thing. But Barnes can never get us, and that's the issue that we're going through. We're not going to lie for Barnes. We're not going to lie to make his thing. We're going to do our analysis the way we do our analysis. And if you disagree, that's fine. If you don't, that's fine. But you'll see, you know, and I believe we're going to review his last thing where, you know, he goes through his little personal attacks and stuff like that. But remember, Barnes's clients are, like, matter of fact, he even sold out one of his clients to try to protect Nick. One of the people he represented in Kiwi Farms, he essentially sold them out to try to run for Nick. So Barnes is that type of guy. So listen, again, I don't have any ill will. His legal analysis are essentially dog shit. They've always been dog shit. Remember, he was the one that's saying Chauvin would never get convicted, and we see how that turned out. So,
Not really.
I heard the police plotting against me trope before too. You should realize that that's what the police are paid to do by the taxpayers. That's true. That's
a little bit.
Yeah. So let me say, Nate, have you talked to Nick? I have talked to Nick. I have talked to Nick. And I've, you know, told him my thoughts. When I spoke to Nick, it was before, you know, all this stuff. Well, you know, me coming on, not now, but before, you know, and it's just like, I think, matter of fact, a lot of people, I think, you know, all of us we are concerned about someone's well-being who within our group. But if you don't want help, I can't give you help if you don't accept the help. So it just is what it is. So I hope Nick the best. Again, like I said, I hope he's able to withstand these charges, not have a criminal record, and get the help he deserves. That would be the best outcome. And I think the part of him getting the help that he needs to overcome this is the most important part. But let's look at Viva and Barnes, and let's see the greatest legal mind on the planet talk about it. Hold you. We're gonna hear him talk about it. So let's go to the beginning of this. Here we go.
All right, Lord.
Conclusions about him that have been disproved.
What's the news with Rekieta?
So multiple aspects. So there are people that had certain factual conclusions about him that have been disproven by the fact that his kids have been returned to him, which doesn't happen if all those factual allegations against him were true.
Well, hold on. His kids being returned to him doesn't mean any of the factual allegations weren't true, right? Like he could have, because you can do certain things to get your kids back. Am I incorrect? Matter of fact, they listed it in that document. They said if he did this, submitted to a drug test, and this, he could, he'd be able to get his kids back. Have people come into the house to make sure the house was good. Remember all that stuff?
I believe that in one of the documents that they mentioned that Candy-Ojai County Child Services said after their investigation, they didn't find sufficient evidence for child neglect or child mistreatment charges, at least to the legal threshold.
You said about in his motion, right? He said that on that May 16th, but that's May 16th. That was before the raid and all this other stuff when they actually found the drugs. Because as soon as you find the drugs in the house, then you kind of have that child neglect issue based on the drugs, not even based on the reports. So I think in May 16th there was not enough evidence, but I think after the raid, you literally got drugs. And
maybe that's what it was then. Yeah, fair enough.
I'm gonna play this. Oops, here we go.
True. That's fact. That's part one. In this criminal case, a member of our board, a member of Rekieta's board, a member of some other boards, a good conscientious criminal defense lawyer, brought motions challenging multiple aspects of the search and seizure. Fourth Amendment violations, Fifth and Sixth Amendment violations, and a kind of a Second Amendment, Fourth Amendment hybrid violation.
Well, just to be clear, any lawyer, criminal defense lawyer, who's not writing an omnibus motion to suppress the search warrant doesn't know what they're doing. Am I right, Kurt? That's like the obvious thing you do, no?
Well, I mean, you always, as a lawyer, I mean, at least 99% of the time as a lawyer, you want to bring any viable argument that is available to you at law. That's part of the duty of zealous representation. So if you have a non-frivolous argument that's furthering your client's interest, then yeah, you want to raise the issue. And even if it's thin. So it's like, okay, I mean, I wasn't mad at the attorney writing the motion. I was like, I don't think it works. I don't think it's frivolous, but I don't think it works. But it's like, yeah, it's what you'd expect them to do.
Yeah. It's on a search, you challenge the search, you challenge the seizure, and you challenge any incriminating statements. You don't want that stuff to come in. So I think this is more obvious than anything else.
So the question is whether statements were coerced from witnesses in violation of their right to counsel and Miranda rights, whether or not the search was procured by fraud, and whether or not the execution of the search was overly broad.
Yeah, stop it.
Absolutely not. Because no matter how much they violated April's rights, it can't possibly have informed the obtaining of the search warrant, because it simply hadn't happened yet.
Yeah.
April's statements only happened once the warrant had been executed.
Correct.
So no matter what they did, no matter how much they violated her rights, it can't possibly be relevant to the affidavit. It can't be possibly relevant to them obtaining the warrant. So to suggest it's based on fraud makes no sense, because time works one direction, man.
But I think this is showing how ignorant Barnes is maybe to the process, where he's thinking she wasn't Mirandized when she was arrested, not knowing that, hey, the search occurred before the arrest, right? They search, they find the drugs, then they arrest. So there's no way that her statements post Miranda could affect the search warrant because she hadn't made them yet. But again, Barnes is, he's, this is the reason why Alex Jones is paying $1 billion, people. Sorry.
Somebody might have mentioned these issues right at the very beginning of the case as staring out from the warrant. And a bunch of the so-called practicing lawyers on LawTube.
Oh, Lord.
By the way, if any practicing lawyer on LawTube is giving the kind of advice these people are on the Rekieta case, note to never hire them.
He's right. You should. If Bart is your lawyer, you should never hire anyone else because this guy is hilarious. And one thing I do love about Barnes is he's so he knows he's like, I'm so good with this conclusion, even though he's, you'll hear later how he goes into it and how he's essentially all over the place. But I love the fact that he's just so confident. And I remember all other practicing lawyers, from myself, Kurt, what's his name, Legal Mindset, Ron Coleman, everyone else who actually practices in court and just doesn't sit there and talk. Barnes looks great talking. Who actually practices in a courtroom are saying Barnes is wrong. Barnes is the only lawyer out there saying, and obviously Rekieta's lawyer. So that's what he has to go up against. Everyone in LawTube saying, you don't know what the F you're talking about, and Barnes saying, I'm the only one that knows.
Well, even Nick's lawyer probably knows it's not going to work.
Yeah.
He just has to try anyway.
The potentially criminal defense lawyer,
Potentially criminal.
Legal mindset that has very interesting travel patterns. The
I like that with his interesting travel patterns. But one thing I'll say about Barnes has no wife. He has no kids, right?
Yeah.
We could say, well, I wonder what's a elderly man like this with no wife and no kids who likes to travel around the world. What is he doing in his spare time? Why can't he, that type of thing. But why though? Why? If you think his argument is bad, just fight his argument. But it shows you, one thing I think this all shows you is Barnes is just a bag of hot air. Because if he really could attack the arguments, he wouldn't need to talk about his travel patterns. He wouldn't need to talk about all this. But that's the reason why, because he has nothing else. He's literally an empty suit. But again, I think this moves some people, but it doesn't move anyone who actually knows.
Nate the lawyer, go back to being a policeman, I think, or covering women's soccer or something.
I cover women's
civil
soccer.
Law, God bless him. Stick to patent law, bro.
You're a patent
Good
lawyer.
Logic's done great conscientious reviews. Don't always agree with him, but he's done very thorough, fair reviews. But most of LawTube has been utter crap on this. They've made legal look sharp. That's how bad it's been. They made legal look sharp.
Wow.
I don't think legal is sharp.
Did he say I did conscientious reviews? Is that what he said?
Yeah. No. You're a patent lawyer. You got to go back to patent law.
What did he say after that? He said someone did conscientious reviews. Was he talking about me?
Oh, no, good logic. He says good logic.
Oh, good logic. Okay.
Yeah, because logic is whatever Barnes says. He's trying not to stoke the well. But just so we all understand too, good logic also agrees with everyone else. Barnes just likes good logic, but good logic agrees with everybody else. He doesn't agree with Barnes.
So a little breakdown of this. So
let's break it down, Barnes.
Rekieta's already won on the Fifth and Sixth Amendment issue. So as I suspected, I was like, I bet they did a lot of illegal crap during this case.
All right, Barnes, you're an idiot. You didn't win on the fifth. How does he not know this? So
yeah. He didn't even win on the constitutional issue. It's hearsay is the more primary problem.
Let me explain Barnes, because obviously he doesn't know what the fuck he's talking about. So let me explain it to you, Robert. Robert, Nick didn't win. The issue is that April may testify against Nick. Those statements that April made in violation of her Miranda rights, the state could not use those statements against April. Right. This is. Let me put myself on full screen, because I think Barnes is just like he's so. Unfortunately, I hate to say this. Maybe he doesn't practice in a while, so he doesn't know what the hell he's talking about. So they can't use those statements against April, but they can use them against Nick. Nick's argument in his motion was simply that April's statements can't be used against him for two reasons. Number one, they hearsay, right? It's not a court statement or for the truth of the matter asserted, and she's not there to testify, they hearsay, so that they would be excluded by the hearsay rule. But second, there's also a confrontation clause issue because she's accusing him of having illicit drugs. Then the confrontation clause would kick in, and his attorney would be allowed to cross-examine her or confront her on the witness stand. So she would have to testify for any of her statements to come in. So the statements made to police, for them to come in, she would have to testify to resolve the hearsay issue. You can confront her with those statements. And if you want to confront her based on what she said to police, then she would have to testify, and that would resolve the confrontation clause issue. So what they came to in the transcripts from what I read was that the judge said, of course, if her statements are going to come in, she's going to have to testify. Does that make sense, Uncivil?
Yep, absolutely.
So Barnes saying he won, it wasn't a win. It was just the reality of the situation. If April's going to testify against Nick, which is more than possible. Now, I think also too, we have to mention is that April could get immunity from the prosecutors to testify. Right?
Sure.
She could get
Very
immunity.
possible.
They could say, we're going to give you immunity. And they give her immunity and then have her testify against Nick. Then Nick could also be screwed in that way. So there's multiple avenues. And that's the reason why you charge all the co-defendants, because you want the flip train to happen, which may be happening in the background, unless we don't know that as of yet. Let me continue on with the madness.
Because the whole thing screamed it. It was like, a case like this normally doesn't progress like this, doesn't proceed like this, doesn't read like this. If you've been around enough of these cases, if you've studied enough of these cases, you knew there were sirens going off and red flags everywhere. And it wasn't Hail Marys or
this is
special
Hail
defense
Marys.
of Nick Rekieta.
I guess I'm reading the wrong kind of cases.
Any case I would look at and say, this case smells like a crap case. So the government has already conceded. Prosecution has already conceded that, we kind of Mirandized one of the witnesses. And
no, they didn't concede that at all.
Yeah, he's just outright like, why lie about it, right?
They didn't concede that at all. They said that it would be hearsay is what they said, and it's like, so we won't use the statements because it's hearsay. They didn't concede about the Miranda. It's also relevant.
You know what Barnes is doing? He's playing to the ignorance of the audience. He's literally playing to he knows most of the people out there aren't going to read the transcript like we did. So he can say something like this and nobody's going to challenge him. But obviously that didn't happen. So you read the transcript. Is what Barnes saying true?
No.
Yeah, it's obviously not true.
No, the judge said that that's a motion for limine and said, you can bring that up at a later time. It's premature.
Yes. So again, why lie? But again, this is what he wanted us to do. He wanted us to lie to you about the contents of the case, and we chose not to do it. So now obviously, pedos and this and that and that's just, again, it's the way he operates, and it's not making legal arguments, he's making personal attacks.
Attorney, and we kind of had another cop coerced testimony out of him, so we can't put
so
that
that's what they said. They had another cop coerced testimony of April.
That's definitely not what they've said. No, not so far. No, they haven't commented on the Miranda issue at all.
So where's he getting all this from? Is it from the transcripts? He's making it up. He's literally making it up, which is crazy.
Confrontation clause rights that are independent. Some people think, unless it's your rights that are violated, you don't have standing. There's
true.
A whole bunch of circumstances.
That is 100%
either
true.
The confrontation clause or the due process clause, where you can find ways to raise third-party standing effective claims.
No, you can't.
I won't go into all the intricacy of it.
You know why he can't go into it? Because he's lying.
Because it doesn't exist. No, the confrontation clause is your confrontation clause. It belongs to you. So you're still raising your own issue. It's like, I have a right to confront the witnesses against me. Yeah, you absolutely do. But you're still invoking your rights. But that motion was written about Miranda. It spent 4 paragraphs or something talking about Miranda. And the very last sentence suddenly brings up the issue of confrontation. I'm like, so I interpreted it as a motion to suppress because that's how it was titled and styled.
It is a motion.
So
it's a motion to suppress her testimony unless she testifies. I'm thinking that they're pressing her not to testify. That's what this is.
It's premature. We don't know what's going to happen. That's a far away about out.
Yes, but I'm saying, that seems to be the lay of the land here. She said something that they don't like. Let's try to suppress it ahead of time, and then now the judge is saying, "Well, wait till the motion to eliminate, and you can make those arguments." But generally, you can't invoke someone else's Miranda rights for them. They have to invoke it themselves.
Right.
But there's a bunch of people that
100%.
didn't understand that basic part. It's like,
You!
what
I
is
didn't
it?
understand it because I didn't
So,
understand
the
it because they
government
hid the
received
issue.
it. Didn't even fight it. Said, "Yep, no problem. Can't introduce those statements." The next set of issues
They didn't not concede it.
Was-
They just simply.
Yeah. Matter of fact, she even said we're going to play the body cam without those statements. But
Yeah, exactly.
but the fact of the matter is they can use April
they concede.
statements.
They conceded it might be hearsay. They conceded that, which it is.
But why lie about it? And but this is a master. I'll say this: this is a master class on how to lie to the audience and make them think that you know something you don't know, and to create a narrative about what happened at the hearing. If we didn't literally read the transcript, you would have to believe him. But we read it, and we know that what he's saying is not true. He's like just outright lying. Can the prosecutor not offer plea deals? Yeah, they can offer.
Sure.
Plea deals. Of course, yeah, they can offer plea deal.
They can
But,
offer a deal. They cannot offer a deal. They can go the distance if they want to.
as I also kind of predicted. So there's two ways to measure a warrant when you're reviewing it. And this basic thing, a lot of these law tubers can't get, these practicing lawyers can't get. No wonder they have like no history of criminal case success that anybody knows about. Which is, one is you assess the cop, another is you assess the court. So for example, when you're assessing whether or not there was probable cause for the warrant to issue, that is looking at what the judge did with what the judge said and what the judge knew. And that's based on what the judge was told. And that can be it's misinterpreted as a deferential standard. It's still a constitutional standard, still federal. You get language and lingo like that, but there's also language and lingo that goes the other way.
He doesn't.
But there's a separate.
He's mixing up the standard, which versus the standard review, deferential to the.
It's pretty deferential, and yes, every once in a while you'll find a court that will kick a court's teeth in on misapplying the law. That's what courts of appeal are for.
Yeah. But
deferential doesn't mean that they win every time, but it's pretty deferential.
Yeah, I think he's mixing up. Like he's mixing up like the novo the standard of review versus the standard for evidence. But again, it's it is what it is.
A different way to challenge the warrant, and it's what I said from the get-go, which is you can challenge whether the cop told the truth.
Yeah,
it's it's loosely after Franks versus Delaware called a Franks hearing. What it is, you tell the judge, "Hey, judge, there was information."
It is not loosely out of Franks. It is like that.
is Franks.
That is Franks. Franks is literally
loosely on the back of a U.S. Supreme Court case.
Yeah. No. That's the test, Barnes. It's called the Franks test. So
information the cop had access to that he failed to tell the judge, and that's how he got the warrant. Mm-hmm. And what's amazing is we don't even require. I think we should.
Well, just to be clear, Franks test has two parts. One that you knowingly, right? The cop knowingly was, so it's not just I had information. You knowingly withheld information, and that information was material to gaining the warrant. So because you're not going to tell the judge everything, but if you told the judge something that was material to get the warrant, like for instance, if like a lot of times in drug cases, you'll have like a timing issue or something like that, where there's something that you would leave out that would let the judge know, like, hey, this, maybe this is why we shouldn't issue the warrant. Then that in itself would be enough to make that warrant that you got invalid. So you have, so it's you can't omit critical evidence, and that's what the Franks test is really. Did the cop omit critical evidence to get the warrant? Am I mischaracterizing the Franks test?
No, it's things that either the cop lied, so he made up stuff, or he failed to include something that would indicate that this person is not responsible, that the cop knows about.
Yes.
So if they're in possession of information with respect to the thing they're searching for that suggests this person didn't do it, then they need to let the court know about that so it can be bounced in accordingly.
Yes.
But we don't require, we don't impose a negligence standard. So we don't say the cop with due diligence would have done boom, boom, boom.
No, because it's essentially like actual malice, right? You have to show that he know or should have known, right? It's that higher standard of knowledge. You have to show the cop knew what was going on, and willfully withheld it.
Boom, boom. I think we should require that to meaningfully enforce the Fourth Amendment to the United States Constitution, but we don't. We just say, don't lie. Don't make stuff up. Don't hide stuff. But everything about what this cop did screamed to me from the very beginning, before I'd even read the search warrant affidavit, just looking at the detention warrant, screamed
Whoa.
that this cop is a
That doesn't make any sense on any level. Okay. So at the risk of pointing out the obvious, the basis to search and the basis to arrest are legally different, not for the least of reasons that you don't necessarily have to have both. You can only have one. So perhaps you have an arrest warrant, but no search warrant, or you have cause to arrest, but no search warrant. That can happen, you know, or the other way around. It's like you have a search warrant, but no arrest warrant. So those two things are don't necessarily come in tandem. So there's really no way to know from the probable cause statement relating to the arrest whether or not the basis for the search was good or not for the least of reasons that, although it would be a bit unlikely, it's not necessarily true that any of the cops that did the search actually applied for the search warrant.
That's true too.
Those could be different cops that came to there that then did it. So there's no reason to believe necessarily that any one of those cops, because of their behavior, somehow informs the search warrant affidavit, particularly because you have no basis to know that they're one and the same. So it's weird.
Well, and there's no way he could have known what evidence was used for the probable cause affidavit based on the arrest warrants, because it was, you had to wait for the affidavit to see what facts and evidence led to the search. So Barnes is essentially, what he's doing, again, this is playing to the audience's ignorance. He thinks that he can say, I predicted it, even though I didn't, because I didn't know it, based on information that had actually nothing to do with the search warrant, because the probable cause affidavit for arrest had everything to do with what was caught in the house from the search.
Right.
Because it had everything to do about the drugs being there, blah, 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 and how they arrested Nick, but it didn't tell you how they came to the search warrant. So there's no way that you can actually know what was behind the search warrant. So I do understand. I understand what he's trying to do. He's trying to say, I predicted it, but unless you know what he's talking about.
Predicted it based on what is my thing. Because, like, how could you have a basis to predict that there's a problem with the search warrant affidavit based on the arrest warrant?
Because they're two separate things.
Exactly. By
Liar.
potentially
This
two
cop is a
potentially
fraud.
two different groups of people.
You don't have to love Nick Rekieta to care about Nick Rekieta to see that. You just have to care about the Constitution of the United States of America and have a little bit of practical lawyering experience. And so turned out the cop lied about tons of stuff. So it turned out.
Now, in that transcript, I didn't hear anything about the cop. Now, Nick has alleged the cop has lied about a whole bunch of stuff, but is there anywhere in that transcript where it says the cop said, I lied about all this stuff?
No, and the state has asked for permission to respond in writing, which I believe is due either Friday or Monday, or no, it's due on the 5th, I think, whatever. But they've asked for permission to respond, and there's been no omission of lying.
So why is he going on? But again, this is what I'm talking about, people. This is why it's dangerous sometimes to I think for Barnes to listen to people who are just not trying to be honest with you. And that's the issue with Barnes. He's not being honest here. There's no way he's telling you what you should believe. And that's why he's not showing you any documents. He's just going to bloviating. And essentially he's lying to the audience. This is pretty despicable. He's lying to the audience. He can say, well, I believe the cop lied. I believe this. But by saying they admitted he lied, where is any of this at? Where's he seeing this? And we've read all the documents and I haven't seen this. So I don't know where these admissions have come at, but why lie to the audience? And I think lying to the audience because he wants to protect Nick. He wants to try to help Nick over this, but I don't think lying to the audience is doing it, if you know what I mean. I just think it's even more despicable. And when people find out you're lying to them, you lose all your credibility.
The Children's Protective Services had already told the cop what's being alleged does not constitute sufficient grounds to allege any kind of child abuse, least of all a crime. Do you think he included that when he mentioned it to the court?
Why
he
would
just
he?
kind of forgot to.
Okay.
Why
So
would they? Why would they? They're searching for drugs, so why would they include it?
yeah, so if let's look at the search warrant. Let's look at the actual. Do I have the complaint? Yeah, I have the search warrant. Let me pull up the search warrant real quick, just to be thorough here, because I want to see if the search warrant, here it is. This is the application for search warrant. So I'm sharing that, and we're going to here. So the search warrant, now if the search warrant is for child endangerment and stuff, then it would say that here. Then yes, that would be highly relevant that the state's saying that the people who deal with this saying it's not. But this search warrant is for controlled substances, namely methamphetamines, cocaine, and other controlled substances. Per familiar. So this is all a controlled substances warrant. This is all a controlled substances warrant. It has nothing here about child neglect. Now, child neglect could help get you probable cause for controlled substances, but it's not the end all be all. So
No.
even so, if you go and they say, well, they're not beating their kids, you're like, okay, cool, because I was worried about the drugs. So a search warrant to find cocaine, he's saying that the cop should have told him that services said that there was no that and matter of fact, the children's services said that it didn't rise to the level of a crime of thing, so they didn't put that. And now if they put that in here, then I would say he has a beef. But this is a search warrant for drugs, not child endangerment, right?
Yeah, exactly.
Yeah, just because they're after you doesn't mean they have cause. That's why they have to prove it. So I don't know. I understand why he's trying to do this, but I just don't. I don't know.
Put that in there. The second thing.
So what's
he
the second
knew
thing, Barnes?
That the weird dude up in Minneapolis,
Aaron,
had said all kinds of crazy stuff about Rekieta. He was citing him like he's a concerned citizen, and he just forgot to mention to the judge. Actually, he's kind of a nut job. Has been saying crazy stuff for 6 months about Rekieta.
Okay.
And then the third part.
Well, hold on. So let's deal with that particularly, Aaron. So he's talking about the part in the motion where Aaron M. Holt, he says so. So let me pull up Nick's motion, because I think this is a good part to pull that up. So let me pull up Nick's motion. So this is Nick's motion, and in Nick's motion, he talks about Aaron and calls him the concerned citizen. Concerned citizen, generally unreliable. And he's talking about Aaron M. Holt, right? That they had beef. So they shouldn't use him as this concerned citizen. Because that's where essentially they got the video. So now when you go to, I want to go to the affidavit for search warrant. So this is the search warrant affidavit. So here, if you look, they do mention Aaron, but they don't mention that they got the information from him. They mention about, if you look, they mention about them being together. They do talk about Aaron a little bit here. They reviewed Aaron's video, and Aaron obviously had getting divorced from April. They explain what videos they looked at, and then they talk about reviewing Nick's video. And here they talk about reviewing Nick's 4.4 hour, 4 hour and 4 minute long video. So they're not saying they reviewed a clip here. They're saying they reviewed the whole thing.
It sounds like they reviewed the whole video.
So
yeah, it's able to review the video that's taken off Nicholas's YouTube and Rumble sites. So he says he's able to view the entire video,
and that
was taken off these sites.
And he gives you the full time and gives you timestamps within the video. Now the video is actually still up on Odyssey. So we'll do when we get to that part, we'll look at those video clips to see if those timestamps match the 4 hour and 4 minute long video. Then obviously the cops saw the 4 hour and 4 minute long video. That's how he was able to get the timestamps. But for Aaron, so let's say everything they're saying about Aaron is true. How does that change anything about this? Because Aaron, it says in both Nicholas and MLT video blogs from Rekieta Studio, they are apparently sitting in the same room. So they're not saying, so it's not saying that he experimented. He said Aaron goes on to say, because again, they're not talking to Aaron directly. They're watching his YouTube streams and saying he's saying these things, that he used coke with Nick. He did this with Nick. He did that with Nick. Right? So he
mentions in here that he and April are getting divorced. He mentions that he and Nick had a falling out as friends. So
They mentioned that in here, right?
Yeah, they did.
Where friends recently had a falling out. So
Yep.
that's even mentioned in the document. So what the hell is Barnes talking about? They did. They were friends. He says they did cocaine together, and they recently had a falling out. So the judge
Friends
knows,
with-
okay.
Is it still friends with benefits if you're sharing each other's companions as opposed to sharing yourself? Is that still friends with benefits, or is that friends with benefits by proxy? What is the correct nomenclature for that one?
That's an extra benefits. But
Okay.
just so now I want the audience to be clear. The cop told the judge here, and you're seeing it in the document, that Aaron and Nick were friends. They had a falling out, and this is what he observed on Aaron's string. Does that now let's see what Barnes says about that, because that's what it was. So I don't get how them telling they literally told the judge everything he just said.
The judge, actually, he's kind of a nut job, has been saying crazy stuff for 6 months.
He's a nut job, and said, but no, he's not a nut job. And again, the cop said, I watched his videos. Here's what he said in his videos. He and Nick were friends, and they had a falling out. What more? Is he supposed to say, oh, he's a nut job? That's a conclusion that, number one, that's a conclusion I don't think the cop can make. But you let the judge come to that conclusion himself. But I think this has given them enough information. I think the document gave them enough information. What do you think?
I think it's relatively sound. I've said so since the very beginning. It looks okay to me.
All right.
I think there's enough here, and I think attacking pieces of it is ultimately a futile gesture, because I don't think you could attack enough pieces to make it matter. And I don't think the cop made a material misrepresentation. Seems like the cop is being forthright to me, so I don't see it.
About Rekieta. And then the third part was he
Okay.
claimed, remember the videotape where he could magically tell what was and wasn't white powder as opposed to what is a flash reflection? And he knew from
Flash
his
reflection.
special video insight that must be cocaine. Extraordinary, even though all the behavior he then describes isn't consistent with taking cocaine.
Technically, he said it was consistent with multi-drug use.
Yeah, well, let's see. This is why it's easy to kind of fact check. So let's see what the cop said about Nick's appearance in the video. And both Nicholas and Monte, Rekieta Studio. So this is it. So did a video blog. It's when they reviewed Nick's video, and he said, so he describes, it appears in the video Nick to be drinking alcoholic beverages, then eventually appears to be under influence of substance or substances. Goes through the entire video. The affiant believes his behavior is indicative of a central nervous system stimulant. The affiant believes in training experience, as well as the behavior of Nick, that he ingested this white powdery substance through the nasal cavity. So he never says it was cocaine. He says it's a white powdery substance that possibly is a controlled substance. So again, I think, and I think Barnes this is the problem with Barnes. I think he doesn't understand the standard for probable cause. Because probable cause, I don't have to prove the thing.
Right.
I got to prove that it's likely the thing is there. So I don't got to prove for a fact that that's cocaine. But let's say if you have packages that look like cocaine and you're the thing, calling them keys. I got keys of Colombian hybrid stuff behind me. I'm not calling it cocaine. It's like, would a reasonable person think that's cocaine?
I got key lime pie, if you know what I mean.
Yeah. So I think he thinks unless the cop goes in there and rubs the damn stuff off Nick's nose and tests it and say, this is cocaine, you don't got probable cause for a warrant. It doesn't work like that, Robert. You don't know what you're talking about. It's all about reasonableness and whether a reasonable person or a reasonable officer with that training experience would look at what was happening with Nick and say, that's cocaine, right? That's cocaine. So that's where we're going with that.
Which I said that screams BS off the plate. Well, of course, he didn't even get the original video. He lied about it. He said, oh yeah, I was watching the original video. No, he didn't even download it. What he did is he saw somebody else talking about it on another video.
No, it doesn't seem to be what he said.
All right, so let's. How many lies is this we're going to be catching Barnes tonight? This is like kind of sad.
It looked like
All
he
right.
said, I saw the original. I just I got somewhere other than YouTube or Rumble.
This is why we go right to the documents. On 5/22/2024, the affiant was able to review the video taken off of Nick's YouTube and Rumble studios. The video was from the 21st, blah, 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 from its basement, court peeling real list. it appears that he was drinking. So, and he says the entire video blog was 4 hours and 4 minutes long. So he's not saying he saw a clip. He's saying he saw the whole thing, right?
Yeah,
And
that seems to be what he's saying.
That's what he's saying. So now let's check to see if he saw the whole thing. Let's look at Rekieta, because he still has this.
Does he still have it online? That's funny.
He still has it up. Yeah,
Wow.
he still has it up.
Nice. Wow.
So, and that same video. So now we can make some predictions. Number one, that video has to be 4 hours long. And if the video is 4 hours long, then we have to look at those timestamps, right? Because that's essentially what we're doing. We're trying to look at those timestamps and whether this video is 4 hours long. So I'm looking at his content. Let me share the screen. So now we're looking at his content. We're looking at 3 months ago. Here it is. Results from my appeal. The video is 4 hours and 4 minutes long. Wow. Okay. 4 hours and 4 minutes long. Now let's go here and review.
Hey, what's up? Good logic.
All right, so this is it. So what are the timestamps? So let's go back to the original document and see the timestamps, because the cop is saying, I saw the full video. So 4 hours and 4 minutes long. Approximately at 2:46 into the video, Nick leaves the room to go use the restroom. So they're going to go to 2:46 on that video.
Yep.
Right?
Roll that beautiful beam footage.
That's how you check to see if the cop looked at the entire video. How would he know the exact time if he just looked at a clip? So we're looking at 2:46. That's 41, 42, 45. All right, so 45, 49 is close enough.
If you're defending a motion, the other side has assumed all the claims are true. We have ways to deal with this. There exists in the common law for fucking ever. I've got a problem. The problem is
46-1.
you're a nation.
Okay.
Kidding. I'm not kidding. That is the problem. I'll be right back. 4 minutes or so. Less, I hope.
Okay.
So he did. The lawyer is pink. So go back to the statement here. 4 minutes
right.
at 2:46. That's what he said. 2:46. He left, right? We see that. Leaves and goes to use the restroom. Comes back at 2:50:40. So he gives even a second. He comes back. Let's now look to see if he comes back at 2:50:40. So here's 2:50:22. So I'm going to play from 2:50:22.
Freedom of liquor doesn't mean freedom from soaking your draw.
2:50:35. 6. It's coming close. He's off by one. Oh no, he's off by 1 second.
What's up,
41.
guys?
Came back.
Oh yeah, that's it. It was 41, not 40. That'll do it, Your Honor.
Oh my God. He's lying. He's lying. He's lying. He's lying. All right. So let's go back. So it looks like the cop watched the entire 4-hour video. He says it here. He appears to be excited. And then he says, look, he appears to be making an excited look and a white powdery substance on his nose. So let's go back. And well, let's read his description first. Let's finish reading his description. There's behavior, blah, blah, blah. Just in the nasal cavity. So that's what he's saying, referred to as snorting. So they believe he snorted. You have to notice throughout the video, Nick was under the influence. So this cop says he didn't watch just a clip. He watched all 4 hours. So now let's see if his description of Nick, as he appears to be making an excited look and a white powdery substance on his nose, your affinity believes his behavior is indicative of central nervous system stimulants. So let's see, based on his training experience. So now we're going back to the video, and I'm going to ask the chat, did this cop describe it right? So I'm going to go pull it back right before it comes in. Here it is. Let's do it.
Hey, what's up, guys? How's it going? So much urine. So much urine. That's what you have to learn. When you're old, you don't pee more. When you drink whiskey, you pee
That is a
shitload.
powdery white substance on the nose.
That's all. That's all. Jim,
He
I
is
don't know
more
if you know
excited.
this,
He
but
has more
there's a
energy.
guy who made shirts with you and your alleged picture on the back. On the back, because the
Is that what the cop described? Is that, or is that a
Mm.
reflection? Is that a reflection?
Well, I mean, it is a reasonable interpretation of what it is. So that it appears to be that. So, I mean, it could be a lot of different things, but it's reasonable to interpret the way the cop did. So, I think it's a fair characterization. It's certainly not a knowing lie. I wouldn't say that.
Barnes got the
Even
cop.
if I disagreed with the characterization, which I think it's fair to disagree with the characterization. I think it's a little bit hard to. I'm not a professional. In my opinion, it's a little bit hard to
There's
tell
like-
exactly what that is. So I think that's fair to say, like, I'm not sure.
It-
Then again,
it-
I'm not sure what I'm looking for, but what do I know?
to me, it could be sugar. It could be anything. But he's just describing what he sees. And again, he doesn't have to prove that's actually cocaine. It's just that could a reasonable person believe that's cocaine? And I think based on all the circumstances we have, it's true.
Yeah.
But the one thing that we were watching this for is because Barnes said the cop lied and just saw a clip. But the cop didn't say he saw a clip. He said he saw
Yeah, I say
four
it's a thing.
and gave exact timestamps of when he saw certain things, right? Those were exact timestamps. How do you get those timestamps if you don't have the full video? I'm asking you, Kurt.
I don't know. Burr told you.
Let's go back to Barnes.
Discovered this going through the process. What he did is he saw somebody else talking about it on another video. And this was disclosed. They discovered.
So is Barnes lying here? 'Cause I want to be fair to him.
It doesn't seem to be correct.
Yeah, I don't know if he's, again, this is what he wants us to do to you guys. He wants us to say these things, right? Even though the documents, even though the evidence, as you see them yourself, doesn't show that, right? He wants us to lie to you. This is what he wants us to say. But we're not saying that because we have eyes and we can read the documents. So
This going through the process. So he hid the fact that he watched somebody else's video of something. There's video of me out there with that people made AI memes of me saying all kinds of crazy things. They have me.
So that was an AI meme of Nick.
If it's AI, it's really good.
That was AI. Like, what is he talking about? People have made AI things that Barnes. Nobody's making AI. Well, again, no one's making AI of you, brother. Nobody's making AI of you. I'm sorry. But this desperate, literally desperate, defensive Nick is embarrassing. Like he's lost all credibility. Let me see. What's this? The cop may have initially seen the clip, which made him look at the full version. I would compare zooming the nose before he went to pee after. That's true. You would look at both. But again, the argument that Barnes is making, I want to be very, very clear, though. Thank you for the super chat, too. I want to be very, very clear. The argument Barnes is making is a cop only watched the clip. He didn't watch the full 4-hour video. We now have read the document, and it seems like to me, the cop said, I watched the 4-hour video, and here's the specific points within that 4-hour video that I want to point the court to. Isn't that what that's what I see? That is what I see. So
me as Breaking Bad. They have me as, there's over 100 versions of it. Imagine some cop getting a warrant for my house because he watched that. And this guy, he lied about that. So what you request is what's called a Frank's hearing.
Yeah. Again, what did the cop lie about? So unless he has some information that the cop didn't watch the entire video, that the cop just made up those timestamps from the video we just saw, because those timestamps were dead on. I think the cop watched the video. I think the cop watched the video. I think he watched the whole 4 hours. It wouldn't make sense. How would he know those timestamps if he did? And he described exactly what we saw in those timestamps.
And the prosecution, if they're worried or nervous that they might lose a Frank's hearing request, is they go in and they request, we need to have special briefing, judge, give us extra time, If they're confident, 90% of the time, they go into the court and say, nah, here's where they're wrong, boom, 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 let's move on. Instead, they go in front of the judge and like, we need extra briefing. Also, we need to figure out how we can try to pretend the cop didn't lie or try to get him to tell another lie, or I, the prosecutor, am thinking about how do I get out of this case.
Wow. Is that what you read off the transcript?
No, and it seems odd to me. I mean, attorneys ask to brief issues all the time, so I don't. That seems odd to me. I mean,
Yeah.
you worked as a prosecutor. Would it be odd to ask for briefing on
No, you know
an
what?
issue if the court? It's like,
So I'm going to explain to you what's going on. I think Barnes just doesn't understand what the fuck he's talking about. The reason why you ask for a briefing is because you don't, as a prosecutor, I don't want to go to a Frank's hearing because I got to call the cops, I got to brief them, I got to prep them for the hearing and all that stuff. It's extra work. And if it's extra work that I can avoid, I'm going to say, well, maybe we can brief this so you can see our arguments. And then if there's no need for it, there's no need for it. So that's why they asked, well, let us brief it and so we can have a formal response out there. And also let you get the judge on record. So right now they're saying based on this, let us at least respond to the allegations because they haven't formally responded except for that hearing. So I think in their response is going to be the cop watched the entire video. And the warrant, the cop says he watched the entire video. He's got timestamps. He says here, I watched all 4 hours of it. You know, so this whole facade that he didn't watch or just watch the clip is a lie. The fact that they're saying he relied totally on Aaron's testimony. I mean, Aaron was the informer. Yeah. That's not true. That's, you know, just read the document. And that's what they're going to do. They're going to compare the application to the document and say, this is not true. This is not true. This is not true. And on top of that, yeah, about the whole child neglect thing. Well, this is a warrant for cocaine. So Barnes, unfortunately, and I hate saying this, Barnes is really exposing himself as someone who doesn't know what the fuck he's talking about. Like, and maybe he should just go back to InfoWars and start, you know, continue talking about the frogs being gay, right? That's it. Maybe that's what he needs to do. Again, Nick claims at Nick's time in the video on private, and the cop couldn't have seen it, forgets it was on Rumble and Odyssey. Yeah, I think that's the problem. He forgot that it was on Rumble and Odyssey. So, and the cop says, I saw the whole 4-hour video and describes what he saw when he saw it with the proper timestamp. So, you know.
If a smart prosecutor uses this as an opportunity to get a plea deal on the table, to get a deal done, that's what a smart prosecutor does. 1 out of 3 cases in drug arrest cases is pled out before the Court of Appeals ever hears of the underlying search warrant issues, right? 1 out of 3 pleads, it gets outright dismissed, right? So, I mean, this is the big issue legally in every case like this. But it turned out the cop was completely rogue, lying, hiding information, fabricating facts, making up claims, intimidating, coercing other cops, intimidating, coercing witnesses in direct violation of their 5th and 6th Amendment rights. And then last but not least, they seized all the guns. Well, there's a little problem. There's no reference to guns in the warrant. The cops had been there at the home previously and had supposedly been following him as a regular follower on his video channel, so they knew he had guns, but they didn't request that the court to seize those. Why? Because they didn't have any evidence it was connected to any criminal activity. Why? Because it might trigger a red flag in a small rural county.
All right, break this down. So I got to explain this. I hate the fact that I got to keep explaining this.
Yeah.
So the cops get a search warrant for coquina. You go into the house, you see the coquina, and you say, hey, there's coquina everywhere, and the April's credit card, in the master bedroom. There's white powder every freaking where. Then you say, while you're doing a search, because you're in there searching for drugs, you see he has firearms.
Yeah.
Well, the firearms now get you to what's called the plain view doctrine. So, hey, I'm in here searching for coquina. I see the firearms, Poppy. Now, under state law, if you got coquina, you can't have the firearms because it makes the firearms illegal. Now, you may have legally bought them and legally purchased them, but if you have cocaine, you can't have the firearms. Black letter law. So the fact that you got the firearms and the cocaine makes you in violation of the law, right? You can't have them both
Yep.
together. So now they don't have to be connected to the drugs. They just have to, you can't have firearms if you have cocaine. There's no connection necessary. Now, for other things, now what Robert Rons is correct about, because I do want to give him credit. In other situations, there has to be a connection. But in this particular case, the thing itself is illegal to have with the cocaine. So
Yep.
that's why you're able to seize the guns, because are having guns with cocaine illegal? Yes. So now that gives you probable cause to seize the guns and then to charge the person with the guns with the violation of not having the guns, but having the guns while having cocaine. And that's what Nick was charged with, having the guns while having cocaine. Go ahead. Uncivil. I said a lot.
No, that sounds right to me. I mean, plain view, as long as you're in the place where you have the right to be, and the places you're allowed to search are the places in which the thing that you're searching for are likely or readily to be found, which in the case of drugs has a tendency to be basically everywhere because people put drugs everywhere. So if you were searching for, as I said, like if you're searching for a stolen car, we can't go look in your bathroom closet because it's not going to be there. The car will not fit there. But drugs can kind of go everywhere. And once we're there, anything we find that's evidence of a crime, we have the ability to see because it's in plain view. The only other option is like, well, because it's evidence of a crime. It's like, okay, so if your argument is I should have gotten a search warrant first, it's like, but then inevitability, because I could have gotten a warrant, and so I'm not going to suppress what I could have gotten. So I don't really think it works.
Now, just so people understand, count 2 of the complaint against Nick. Count 2, possessing ammo or firearms, user of controlled substances. That's what you got here. You got a user of controlled substances with firearms. And you have probable cause because you just issued a search warrant and found the cocaine.
Yep. Don't tell the feds, man. They'll pull a Hunter Biden on you.
Yeah, and this is not even a federal offense. People are putting federal offense. No, this is Minnesota statute 624.713.
It's both.
Yes. It's a gross misdemeanor. It's not even a felony. But yeah. So having the guns with the drugs gives you probable cause to seize the guns. Again, I don't know if Barnes knows this. Maybe he needs to go and maybe read a law book or something. I just don't know. But I love how it's just but it's crazy how he's arguing that we don't know what we're talking about, and then literally it's just making it up.
And as I said when I was reviewing this earlier, if you took this argument at face value, it would suggest the police are there to find drugs. And while they're there, they find the body. It's like, are you really telling me they can't seize the body now that they see the body that's in plain view because it wasn't in their search warrant? That doesn't sound right. That doesn't sound right. So, yeah.
All right. So it's a good question. Good logic. Do you need a new warrant to search the gun? No. See, as Justice Clarence Thomas always says, the core issue with the Fourth Amendment is reasonable.
Yeah.
So the warrant requirement is the check. But if it's reasonable at that time, if a cop sees something illegal, at that time, that gives you the probable cause necessary to seize it, because the requirement of the Fourth Amendment is probable cause for the seizure. That's why you can get a warrant to arrest someone, or if the cop is there and can gain probable cause. Let's say, for instance, in a fight, if one person slaps somebody else, the cop doesn't need to get an arrest warrant to arrest that person. If the cop is there, they can arrest because they have probable cause to make that seizure right there. So in that case, because the guns are in the house, they have the warrant to seize the drugs, but they don't need a warrant to seize the guns because the probable cause they have is from them being with the drugs. I hope that answered that question.
Yeah, and even if you did need a new warrant, it's like, yeah, but the judge would have issued it, and so it all would have happened. So
then you got inevitable.
It's discovery. Like you get inevitable anyway. So it's like, because suppression is suppression is a somewhat extreme remedy in some senses because you're excluding what is evidence from being used. And so the Supreme Court has somewhat tailored it to only apply if it is essentially the necessary byproduct of what the cops did that was wrong. But if there's another way to get to it that's legal, if there's some other mechanism, then they don't suppress. So suppression is not quite a magic bullet.
But this is obviously plain view, though. It's
I
obviously
agree.
It's obviously a plain view argument, right? We found the drugs. Now, the good part about this for Nick is if he can get the search warrant bounce, then the guns go, the gun charges go, the drug charges go, everything goes. Because it's all fruit of the poisonous tree. The search warrant for the drugs, if that's bad, then the gun charges go. So getting that search warrant out is key for Nick. And I think that's the thing that he needs to focus on, getting that search warrant bounced.
Yep. Sounds right.
Hold on a second. You want to go grab somebody's guns? What's going on here? So, but what do they do when they get there? They're like, yeah, we're just going to grab it. And they grab random stuff, by the way. Well, there's a word for that or phrase for it. It's called general warrant. And it's called, otherwise known as, for all the constitutionally illiterate practicing lawyers out there, unconstitutional. It's why the Fourth Amendment exists.
But it shows you he doesn't know anything about plain view. He doesn't know a bit about warrant exceptions. It's like it's crazy. This guy, does he not know this? Like Kurt.
Yeah.
Like
I mean,
really?
the only things they seized were drugs, drug paraphernalia. So I'm trying to think of anything other than what was listed on the warrant or the guns that they seized. It's like I can't think of anything. All they seized were drugs or paraphernalia or so. Yeah, it doesn't make sense. I don't get it.
Yeah, I'm gonna link in. I think Linda told me to link in Joe, so I'm gonna.
Is Joe coming on? That's nice.
Send Joe, yeah. So I'll send Joe the link. Joe, the link is in. I sent it to you via Twitter. All right, so Joe's got the link. So it went out to Good Logics. All right, there it is. So yeah. So I don't. Again, let's continue on.
To get rid of general warrants. Now, here's how cops have been trying to.
So, all right. So just so everybody understands, this is not a general warrant. It's a specific warrant for cocaine. So I go into the house looking for cocaine and I see a dead body. Right? I can arrest you for murder, right? Or I see something else illegal. I can arrest you for those illegal things. So it's not a general warrant. The warrant was specific. The circumstances and you getting other stuff is a little different. Oh, here comes Joe.
Yay.
Joe, what's going on?
How are you? I gotta move my okay, first, is my audio okay? Because I move my studio whenever I move, my audio goes to hell.
Yeah, it sounds okay. It sounds okay to me.
It's not quite the quality that I'd expect, but
yes, it's not your usual quality.
I know it's doing the wrong thing. Damn it. All right. I think what Robert's getting at is similar to what I heard Nick get at. And you all know I'm not a criminal defense attorney. Okay. But I just I think you're all dismissing their argument as being stupid or irrational or not sounding like this is something a lawyer would ever say. And I think that dismissal is, pardon the pun, unwarranted.
Okay.
Perhaps, assuming that their legal take is correct. But I know that when Nick was going through his motion, to the extent he was able to go through it, he made a point that when you get a specific warrant to go after a specific thing, and then you find evidence of another crime, you are duty bound before you seize evidence of a different crime to actually get a warrant to take and say, hey, look, we're only allowed to take this stuff, even if it's in plain view. The plain view doesn't open you up to say, now that we have a specific warrant for crimes, alleged crimes A, B, C, then now we can start pulling up other stuff that might be evidence of issues D, E, and F. Now, in a scenario where, let's say, there's some sort of emergency or there's a danger to the cop, then in that case, I can understand there being exception to that. But in this particular scenario, I know Nick's take is, and I think this is what Barnes is getting at also, that seeing as how the house was secured, no one's resisting arrest there. They're in control of the entire premises. That there is a legal constitutional duty upon them not to extend a warrant that is exclusively given the right to search, and a warrant is two separate elements. A warrant not just to search, but to also seize evidence of drugs. Now, if you want to go into other crimes like possession of firearms or issues related to neglect that you now think you find, much as if, they go on and search someone's house and all of a sudden they're looking to find drugs and they find CP. You can't just start, collecting those pictures. You would need to actually ask a judge and say, hey, look, we think this is CP. We're not sure, but we think it's CP. So we want a warrant to seize this, and you'll get that warrant in 5 minutes. But it's a procedural step that they're obligated to do in order to help keep that divide, the constitutionally recognized divide between the state and the citizen, that there's a neutral arbiter in between who says, yes, go ahead and seize this. And I think their point is, I think what Nick and Barnes' point is that with respect to the guns, you can't just take those guns when the place is secured and you haven't gotten a warrant for it. And they should have gotten a warrant, and they could have gotten a warrant, but they didn't. And accordingly, those guns now, as far as evidentiary value, may be suppressible because they're seized absent a warrant. I think that's what Nick's point was, as I understood it when he explained it. If I'm mistaken about the law here, now you want to tell me that there's a plain sight exception that now says not you're allowed to actually seize it, that I'm wrong about that? You might be right on that. But I'll tell you, that's what I understood their argument.
All right. So two things. One, Barnes is putting himself out as a criminal defense guru, right? So, and I've written search warrants, executed search warrants, and I've defended search warrants as a prosecutor and a cop. So I can tell you from my experience is that if we're going into a place and we're looking for item A, right? But in this case, it's cocaine. Then we go in, and so there are a couple of rules that you can't overcome. Like we used to call it the elephant in a suitcase rule. If I'm looking for an elephant, I can't look in your suitcase, right? So if that happens, then obviously, so if I'm looking for a person, then I look into your purse to see if a person's in there. That doesn't work. So there are rules on how you can search. But in this case, especially when you're talking about drugs, you're talking about something that's very small. So you don't have this elephant in a suitcase issue.
Right.
That's what Kurt was speaking to earlier. So now we're talking about the plain view exception is if a cop is legally in a particular place, besides the warrant, legally in a place and sees criminal activity, you see cocaine, you see whatever, you can search it. Let's say, for instance, if a cop is on the street and sees somebody doing a drug deal, they can arrest that person, but do they need a warrant to now search that person and remove the drugs from their pocket? No, because the drugs, even though I'm arresting that person, I can still seize anything else. They may have a gun. I can seize that gun, and I can charge them with the gun violation. So in this particular case, when they went into Nick's house with the warrant, their warrant gave them the legal right to be in that place. Now, when they're in that place, the cocaine is illegal. So now they seize the cocaine. Now, if you see something else that's illegal in there, you can seize it because the Fourth Amendment guarantees you can seize stuff. The government can seize stuff based on probable cause. So you're telling me.
I'll take it to a different thing. I'll stay away from the gross type of crimes. Let's say they see a whole bunch of financial records that they say, in our estimation, this looks like tax fraud. They go in there on a drug bust and they're like, we think this is tax fraud. So we're going to seize all of their files here because we think all their files, which are in our site, we have the right to take these files because we think that this is evidence of tax fraud.
Let me stop you right there. The law says it has to be obvious. Plain view is not about me looking through your papers and evaluating it. It has to be obviously illegal.
It's plain sight. It's sitting there.
And also in your example, the problem there is that there's an additional intrusion because they would presumably have to remove the top page to look at additional pages because there was a case I think that went to the U.S. Supreme Court, if memory serves correctly, where the cops were looking at a gun and they looked at the serial number, but in order to look at the serial number, they had to move something. In order to look at the serial number.
And that was
it's like, no, that's an additional intrusion because it wasn't in plain view because you had to move something to go see the thing. It wasn't plain view.
You're not really arguing with me on a specific rather than the philosophy. Here, I'll make it very simple for you. I'll make it very simple for you. You're there on a drug bust, and sitting there, you're there on a drug bust, and sitting there on the screen, is a big screen that takes up the whole room, coming from a computer, is a thing which says, this is our tax fraud scheme. Okay, and it's very clear that this is a tax fraud scheme that they sold for that this company was using, and the CEO who you're doing a drug bust on, that this is his tax fraud scheme. So are you telling me that for your drug bust now, that you don't need to get an additional warrant to seize that computer? You can take that computer because it's in plain sight now that coming from this computer is evidence of tax fraud. I'm not asking you, and that's the plain view that you're saying that you don't need to get another. You don't. I don't know the law. I don't know. I'm not telling you I know the law. I'm telling you, to me, I would think you might need another warrant on that.
I'm just trying to explain to you how the law is in this particular instance, right? Plain view is just about if I see something obvious criminal activity aside from the other criminals. So you're saying there's a computer there, and they have on the computer, this is our blah, 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 blah. If they seize that and take it to a judge and says, Judge, on the computer, it says, these are all our criminal activities. These were crimes. You know what the judge is going to say? Well, if it's plain view, and you can see it from when you were searching, you can see it and you can read it just like anybody else.
Then you're allowed to seize it.
Matter of fact, it is so. Hold on, let me just make it even more clear. There's a case in which the cops smelled something, and they argued, "Oh my God, the cops smelled it. It wasn't in plain sight. It wasn't plain view." They were like, "Well, the cops can even use their sense of smell. They smell like marijuana, or whatever." To also say that that's enough for criminal activity for a search. So the cops can use any of all of their senses. But in this particular case, the plain view doctrine has to deal with something that is obviously illegal. And so if Nick's, let's say for instance, if Nick's guns were somewhere where it wasn't obvious, it was locked up, it was somewhere where the cops had to go this extra mile to go find them. Yes, you can make the argument, but if they're in plain view in the search area, and they say, well, you got cocaine here, well, you got guns, you can't have guns with cocaine. The guns now are illegal because you have cocaine there. So yes, you have, and the key point to this is that you have probable cause that a crime has been committed. You have guns with cocaine. The probable cause is that you see it, you're in the house with it, you see it as the cop. That gives you probable cause to seize the cocaine and to seize the guns.
To my understanding of probable cause gives you a license to make sure that you're safe from being harmed by this potential criminal, and then to go get a warrant. Probable cause itself is not a warrant. That's my point. And that's why, it sounds as if you're treating the probable cause of this additional crime as in and of itself a warrant. And I don't know. I haven't researched the law. I don't know. So what I'm saying is, sounds as if why so once you have probable cause, why do you need a warrant? You have probable cause.
So this is all right. So this is all right. So just to let you understand how it works, the Fourth Amendment guarantees you rights from.
You're saying once they're in there, I understood what you were saying. That you're saying the probable cause plus a warrant that they opens up license for a warrant on everything.
Hold on. What you're saying is that why don't you need a warrant for everything, right? Because technically, every arrest, most like 90% of the arrests, any police officers in the chat is going to tell you 99% of the arrests they make are warrantless arrests. Right. They're seizing people without warrants, but the Constitution says you need a warrant to make that arrest. So how do you overcome that, right? Millions of people are being arrested without warrants all the time. That's because the warrant requirement is a requirement to go to a judicial officer and you can get arrest warrant. But you can obtain probable cause through other means. You don't have to go to a judge and say, here's my proof of probable cause. Probable cause can be apparent. So for instance, if I'm a cop in the street and I see one person shoot someone else, I don't need to then go to a judge and say, hey, I saw this guy shoot, to give me a warrant. As a police officer, I've seen that shooting, and now I have probable cause to make an arrest and seize the evidence of the crime. So the warrant, you can have the warrant, or the police officer can develop probable cause through other means. But Justice Clarence Thomas makes this point clear. The key point of the Fourth Amendment is the reasonableness requirement, and probable cause is the determination of reasonableness. So that's why a lot of times if a cop arrests someone without probable cause, you can then sue them. But probable cause is the key element for search and for seizure. The warrant is great to have, but it's probable cause that the police need to do either. And
So
99% of searches and seizures happen without a warrant, or dependent on probable cause.
So I was under the impression that the reason why you have all those warrantless arrests is because the cop there is in an exigent type of circumstance, meaning you just saw someone grabs a purse or hold up a gas station. So now we're not going to put the cop in danger by making him go through, call a judge and say, hey, can I have a warrant to arrest this guy? But that once you have an area that's already secured, that if you're going to be seizing additional stuff that are outside the purview of the underlying warrant, that you would need to get a second warrant, because there's nothing stopping you from getting that warrant. There's no danger to the cop. There's no reason not to make them go through that step to make sure that they're not unreasonably seizing a computer and claiming, oh yeah, you know what I'm saying? This way they can say, this is what we see. Can we now seize this computer? It kind of makes sense to me that would be a required step. But again, I'm not claiming I know the law on this element of it. As it happens, I'm actually rebutting. I told Kurt earlier today in my stream that I'm starting in 15 minutes or 13 minutes. I got to get my notifications out. That is actually rebutting his assessment of oral arguments. I wasn't planning on addressing this particular topic. When you were talking about this, it made me think that I want to weigh in and get your opinion on this. You're telling me I'm wrong. You're telling me I'm wrong on the law, though. That's you're telling me I'm wrong on the law as far as needing a new warrant.
But I just want to be extremely clear. 99% of searches and seizures that happen by the government happen through warrantless arrest. There is no warrant involved, because as long as the police develop probable cause for the search or the seizure, that is enough. Now, Kurt has a case, Horton v. California.
Yeah, while you guys have been talking, I've been doing some case law research in the background. So this case seems like it might be on point. Horton versus California, U.S. Supreme Court, 1990. In January 1985, the treasurer of the San Jose Coin Club returns from the proceeds from an annual coin convention which Terry Bruce Horton attended. Upon entering the garage, two robbers accosted him, one with a machine gun, another with electric shocking device. They threw him to the ground, shocked him, and robbed him. Sergeant Leveler determined there was enough evidence to do a search of the home and obtained a warrant. His affidavit for the search warrant described both weapons and the proceeds of the robbery, but the warrant only granted permission to look for stolen property. While searching the house, he did not find the property, but he did find a machine gun, a .38 caliber revolver, 2 stun guns, and a handcuff key. So it's like, okay, in this case, this guy gets only a warrant for the proceeds of the robbery, but while he's there, he finds all these machine guns.
Yes.
Okay, so he seizes them. The evidence was admitted into trial, and Horton was found guilty. Court of Appeals affirms. The California Supreme Court denies review. Question: does the Fourth Amendment prohibit warrantless seizure of evidence in plain sight if the discovery of such evidence was not inadvertence? No. Writing for a 7-2 majority held the seizure of evidence in plain view does not constitute invasion of privacy that the Fourth Amendment is meant to prohibit. Once an officer has a warrant to search a house, that officer may seize any obviously incriminating evidence the officer finds in plain view.
Yeah,
so I think this case
perfect.
seems to suggest against.
No, it doesn't suggest.
It's black letter law.
It blows up my argument. It blows up my argument completely on this particular element. I agree with you 100%. That being the Horton seems to be right on point. It blows up my argument that I was saying they need to get a new warrant. Supreme Court says, no, Joe, they don't. So you're right. And my thoughts on this, which this is how I understood Nick and Barnes to be arguing. I might have misinterpreted their argument, but that's how I understood their argument. I'm glad you actually helped bring that case to light. And you're right, and I was wrong on this.
Well, take a closer look at it if you like and make sure. But it seems to be on point because the guy's like, yeah, I only had a warrant for the. I only had a warrant for the. I even went so far as to ask for permission to seize both the weapons and the proceeds, and I didn't even get it. All I got was the permission to get the proceeds, and I didn't even find the proceeds. All I found was the weapons, and that's all I seized and prosecuted based on that, and that was okay. So I'm like, well, that seems to, yeah.
Yeah,
Right,
and
cool.
the only issue is that Barnes knows if Barnes is a defense attorney, he would know this because this is black letter law in criminal defense. But you know, his clients do some real time.
I got to bounce. Maybe if you want to redirect people over to me when you're done, I'd appreciate it.
Oh, okay, cool. I'll set it up right after.
Thank you, brother.
All right, brother.
Take care.
They get away with this for years. They get a specific warrant saying we're going to get this, and this, and then they go in and they say, oh, it's in plain view. I just saw it. Well, of course, that is basically it. As courts started to figure out, hold on a second, that would be meaning you have a general warrant. I give you a warrant for something particular, but anything you see while you're in there, you can take. That's a general warrant.
you see, Bar. I'm glad you pulled up the case law because he's just he said the Supreme Court is wrong. The Supreme Court is wrong. Did you hear that?
Well, Supreme Court might be wrong, but and hey, if you want to disagree with the U.S. Supreme Court, you have my blessing. I disagree with the Supreme Court all the time, but not as much since they struck down Chevron, baby. Woo!
Chevron is gone. But this plain view doctrine has been the law for so long. It's like ridiculous. Everybody, but again, if he's a criminal defense attorney and he doesn't know about the plain view doctrine, don't hire this man because he's going to get you locked up. Plain view is a thing. Plain view is a thing.
You have a general warrant.
It's not a general
I give you a warrant for something particular, but anything you see while you're in there, you can take.
Anything you see that's obviously illegal.
Yeah, it does have to be open. It has to be open. It has to be obvious. It has to be in a place you're entitled to be. You cannot do any additional intrusion. So you can't move the piece of cloth because the gun is partially covered by a t-shirt. You can't move the t-shirt to look at the serial number to confirm it's the gun. You can't do that. But as long as you're in the right, you have the place to be, as long as it's in plain view, as long as it's no new intrusion, as long as it's obviously evidence of a crime, then it seems like you're there.
Yeah.
So, yeah.
That's a general warrant, which is exactly what the Fourth Amendment is supposed to always prohibit. It has to be particular with what it describes as to what is searched and what is seized. And so that was problematic. They seized all the guns, charged them with things related to the guns. The problem is they had no basis to seize the guns. The guns weren't related to they knew about it before and didn't even request it seizure, didn't get approval from the warrant, and it wasn't connected somehow. They didn't see, oh, I see the gun connected to this somehow.
I'm almost embarrassed for Barnes for making these arguments, right? I'm almost embarrassed for him because anyone who knows anything about this part of law would know what he's talking is full BS. But
that makes it a nexus to the underlying criminal activity that you're allowed to search in, because that's the limitation they impose on plain view, which means all of the gun-related charges have to be thrown and the enhancements would have to be thrown out. So he's got robust constitutional issues.
I love how Viva just stays there the whole time and just He'll smile once in a while, but he's just it's the Barnes show.
So I want to ask, what are the extent of a drug warrant? If they look in a purse for drugs but find a gun, is that fair game? Yeah, I would think so.
Yep.
Because if they're looking in assuming the premise, they have the right to look inside the purse and they find drugs inside the purse, and there is also a gun inside the purse. Well, that suggests very strongly that the gun and the drugs are in the possession of the same person because they're both in the same purse. So I think, yes, they could seize the drugs in such a situation. I would think so.
Now, who knows with a state trial court judge? 9 out of 10 are in the pocket of the prosecutor, and they're complete wusses and not willing to enforce the Constitution when it comes to these issues. So that there's always that issue. But if you're the prosecutor, do you really want to keep going forward on this case, which is for the cases you typically have at the bottom of the pile, frankly? So somebody like to party a lot, that's your big crime?
Well, I think Bill Barnes is trying to play it down. He was caught with felony weight, right? This wasn't just like a
second degree felony weight at that.
Yeah. So this wasn't, this is they could have, technically, maybe because of sometimes the
but it doesn't pass the 1 kilogram exception. Do you know the 1 kilogram exception?
No, it's the 1 kilogram.
I don't know if this is a real thing, but I once heard a law professor or someone remark on that. It's like, no matter what the police did, no matter how illegal it is, no matter how much they violate your rights, if the amount of drugs is 1 kilogram or more, it's coming in.
That sucks. But I'll say in this case, he was charged with the second degree possession of 25 grams or more. That's felony weight. That is just not some grains in your pocket. That's enough to repackage. So it's Barnes is underselling it here.
I mean, come on. If you're a local prosecutor, you're dealing with real crimes. No, not this, minor stuff.
Minor stuff. The guy's caught with 25 grand.
It's a second degree thing. I mean,
second degree felony.
The state of Minnesota apparently thinks it's fairly serious.
Yeah, like a second degree felony with fire.
25-year theoretical sentence. They seem to think it's fairly serious.
Yeah. This is not serious. This is the bottom of the barrel. He's hit with a major felony. Yeah, don't worry about it. Cocaine being in the kids system. Don't worry about it. This is nothing. People do things like this all the time. They AI'd me. What the Barnes is funny.
So smart prosecutor dumps this case and doesn't have Fourth Amendment law that embarrasses the entire police department, embarrasses the entire prosecutor, potentially embarrasses the judge. That's what they
embarrasses, unfortunately.
But I don't know if they got a smart prosecutor.
Seems not to understand.
But now I remember in the original charging documents, or at least when we got additional documents, it said that the way they got to the felony amount of the cocaine or whatever it was, 25 grams, was by including the packaging. Have they reduced that, or is there?
They added that. They haven't. At some point, they're going to have to reduce that dramatically as well. So a lot of the
very well may, and I've said that since the very beginning. I was like, they very well may wind up doing it. So it might drop to third degree by operational law. That'd be fantastic.
That means that's all crap, and the enhancement's all crap. The measurement was always crap, so they have other issues. I'm sure there's probably other evidentiary defenses.
There's not an enhancement, by the way.
Repeatedly to get the warrant. If you take out, so what's materiality?
He's wrong about that.
Materiality is why did they put it in the warrant? This is how I always respond.
The enhancement he's referring to, and the only reason I know this is from the prior videos, he's referring to the enhancement that would come if a gun or a firearm is used in the commission of the drug offense.
Mm-hmm.
So if the gun was used during the commission of the crime, then that enhancement changes the thresholds.
Yeah.
And if memory serves correctly, if that were the case, this would now be first degree, because it effectively bumps it up a degree in practice. But this isn't an enhancement. The gun was not used in the commission of the crime, and they're not arguing it was. They're just arguing that there's a gun there that's in the possession of a person who's prohibited. So it's not an enhancement. It's a separate charge. If it were an enhancement, we'd be in a whole different world of pain.
Yeah. He's looking at first degree, and then the gun charges would be more serious. Yeah. But it's good to lie to the crowd and just call them an enhancement. Who's going to know?
I do.
But I've dealt with these issues in front of judges. Said, Judge, if it didn't matter to the warrant, then why was it in the warrant? Right. And so 9 times out of 10, if it's in the warrant, it's material to the warrant.
No, you can have things in the warrant for context, but they're not material for the warrant. I'm hoping he's just joking around with this. He's got to know this. Of course, you're going to have things in the warrant that may not be material. That's why the fact we have the Frank's test, which talks about things that are material to the warrant or not. If everything was material, they wouldn't have to have that second prong of the Frank's test. But I don't think he just understands that.
Like the evidence in the New York case.
Yeah, exactly. Now, if you take out, and I mean, there's other stuff they haven't even got into yet that's problematic in the warrant. But this is just, did the cop lie? And it's just requesting an evidentiary hearing. Say, let's have an evidence. Let's put the cop on the stand.
You know what? This is a good transition to this. Based on Barnes's argument, or based on Rekieta's argument about the cop lying, they're saying the cop lying about essentially three things. Number one, that he didn't tell the judge. He omitted the evidence of telling the judge about the conclusion that the social workers didn't think that there was enough for child neglect. That's one. But now you have the argument of that. Was that material to this warrant or not? So I think that's the first one. You can make the argument. The second one is the second argument seems to be that the cop lied when he said that he saw the entire video. He only saw a clip of it. But nowhere in the transcript or in any of the paperwork did the cop admit that he lied or even said that he lied. As a matter of fact, he says he watched the 4 hours and even gives specific timestamps, which makes me think that he did watch the 4-hour video. So I'm assuming the state's response is going to say that. And then the third thing that they're saying the cop lied about is that he omitted the fact that Aaron Immelt, he doesn't say that he's a lunatic. He's supposed to tell the judge, this guy's a lunatic. Now, I don't think anybody's going to say just a concern is a lunatic or anything like that, or it's crazy. But he did say that they were friends and had a falling out, which shows his bias. So based on what I'm seeing now, I don't think a Frank's hearing would actually, like, if I'm a judge, I don't know if I would give a Frank's hearing, because unless you can show me evidence that the cop actually did lie, because from everything that we've seen, it doesn't seem like he lied, or unless you could show me that first piece the first piece about the child services worker saying that it's not enough, unless that was so material that could overturn the one. But I don't see why you would have a Franks hearing unless the judge just wants to be overly cautious and have a Franks hearing. How do you feel about a Franks hearing?
No, I don't think so. It doesn't work for me.
Let's get the evidence and let's see what happened. Did he lie or not, Judge? You get to assess him. You're here every day. He grants him that hearing. If you're a prosecutor, you look at this file. There's no way you let that dimwit get up on the stand. You let a cop that's so dumb he lied about stuff they could prove with things that were sent in the mail.
But again, see, so I love the fact that he's working off the assumption that the cop lied, but has not shown us one stitch of evidence that the cop actually lied. He hasn't shown us anything about the cop actually lying. He just keeps repeating it. But I think this is how Barnes operates, right? The more you say it, the more people are going to believe it, right?
Yeah.
Never in writing, always in cash. This cop clearly forgot that lesson. It's amazing. Corrupt cops love their prints. They write this stuff, but they put it in emails and other communication. They're just because they convince themselves of their fraud and their lies. You've got a completely crooked cop here. And you've got multiple crooked cops because there were other crooked cops at the scene doing illegal things. So you got multiple levels of crooked cops. And someone's going to convince me it's a total coincidence that the person being targeted is one of the biggest critics of the local law enforcement community? Come on. I mean, what world do you people live in? You don't have to believe in tentacular conspiracies. They saw an opportunity to screw somebody that had been a pain in their rear, and they decided to do so. It's simple as math.
So just to be clear, to show you, just to put a bow on this, I want to list out the people. I think I have a list of who was listed in the warrant to get the to get probable cause. And because he's saying this was the crooked cops in that area who did this. So I have a list here. I'm gonna see if I can find my list. But I have a list of everybody who's listed in the warrant who gave information to help obtain probable cause in this case. So where's my list then? So I'm just going to read them off. First, it was the pastor. The pastor was the one that made the original mandatory report about the kids not being, with the clothes and all the time. Then you have the former live-in nanny, who also raised concerns about the issue, what was going on and all that stuff. Then you have a former tenant who wasn't mentioned, who's mentioned also for probable cause. You have the preschool teacher of the church who also made statements about his appearance, blah, 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 this, and the kid's appearance. Then you have anonymous individuals like Nick's wife's, his sister-in-law. His sister-in-law is mentioned as one of the anonymous sources in the document. And there are other anonymous sources in the document other than just the cops. So the cops have all these anonymous sources, people from Nick's church, other family members, the stepsister, all of these people are making these statements to law enforcement. This guy's got a problem. The kids are blah, blah, this, and police investigate and they find this. So he's trying to make it out to say that police just went on a fishing expedition and had no other evidence. But the fact of the matter is, when you look at the document, matter of fact, let me show you the doc just so you guys can see it. Nick's sister-in-law is listed in the document. Let me see. Let me pull this up just so people, it's in a supplemental report. Here it is. Nick's sister, I admit, took out the kids. Here is the preschool teacher, sister of Kayla Rekieta. These are some of the witnesses who gave information to help them into probable cause. So, so this big conspiracy is great for him to say. It's great, but it doesn't hold up any real water to what's really going on.
That's why I live in Vegas, but don't practice law in Vegas. I don't want these boys knocking on my door. So I'm careful where I come out. I parachute in like a mercenary, and I get back to my Swiss mountains.
What?
That's so he doesn't practice in Vegas because he doesn't want the police to or maybe he just
I continue not to completely understand this statement because I am quite positive that there are quite a lot of lawyers who live in Vegas. In fact, if I had to put a bet on it, I would think that they might have a above average population of lawyers for a major city because of things that happen in Vegas. So I think there's quite a lot of lawyers, including ones who do criminal law in Vegas, I would think.
Well, maybe
especially
only
criminal law
right?
in Vegas.
Or maybe it's only good lawyers, right? In Vegas. Yeah, he doesn't practice in Vegas. Maybe because he can't. Maybe that might be the issue. But yeah, he's just being stupid.
But it's clear that this has crooked cops written all over it. And if you're a smart prosecutor, do you let that crooked cop be an idiot take the stand? God knows what dumb lie he's going to make up. This guy was dumb enough to lie about things there's written proof of. So if you're a smart prosecutor, you get out of this case now. You finish this, conclude this, write this up. But I don't know if they're smart enough, so we might get to see these crooked cop embarrass himself right on the stand.
If it comes to that, it'll be amazing.
Oh, it'll be amazing. Yeah. let me get this super chat. How the hell does he get over the deal, given his outlandish accusations? This is how you turn the first offense into prison time.
Well, Nick so far hasn't been making any outlandish accusations in his writing. So far in his writing, he's been quite tempered and reasoned.
And I think
perhaps,
Nick is
whatever.
And I do think Nick has to like there's a like a dual-edged thing that you kind of have to do here. On one end, he's got to try, because again, he's an internet personality, so he's got to keep the fans involved in what he's doing, but on the other side, he's got to protect his case, right? So I think in that realm, I do understand Nick. He's in a tight spot, he's in a tight spot, and it's got to suck to have your life, being put out here on blast, but it's just what it is. I again, like I said, I hope they dismiss this. He gets help and they call it a day. But maybe I'm asking for too much. So,
he should have kept the cocaine in the flour bag in the kitchen.
Oh, that'd have been interesting. And I don't know if Barnes is like, I understand why he's doing it, right? I understand he wants to be helpful to Nick. He wants to continue to promote Nick. That's why. But to what extent do you give up your own personal credibility? And essentially, because again, he's literally just lying to the audience. He's just literally lying to people, lying to all those thousands of people that they talk to. They're just being lied to. And then when you find out that, hey, because most of these people aren't going to read the documents that we just did and see the cop watch the whole entire 4 hours and literally points out in the 4-hour videos where he saw things, because he doesn't want to see it. But as long as I can tell you what's not there, then most people aren't going to believe him. But he's, it's embarrassing. And I used to respect Barnes. I used to respect him, but I don't think that you can respect someone who just obviously thinks that all of the followers that follow him and listen to him are fools. Those arguments he's making is because I think he thinks that you guys are idiots, and he can tell you anything. He can at least make it up. And as long as he says it, you'll believe it and don't question it. And unfortunately, I'm just not like that. I have to question it. I have to see to make sure what you're telling me isn't just BS. And Barnes, and that's the reason why I think me and Barnes don't get along, because you can't just tell me something. I got to see it for myself. So what you got going on after this, bro?
Well, I got some great stories coming up on my channel. We're continuing on the video on demand thing that we're doing recently. So coming up on my channel soon, I believe we are doing a TikTok case tomorrow. This is a woman who went to a bar in Chicago and said that she was assaulted, but not so much with the assault. And now the bar is suing her for defamation, because she, had 1 million people watch her TikTok video and they're not happy about it. Then we've got a video coming out about the Karen Reed civil lawsuit. Following that, we have a lawsuit coming out about the Girardi guilty plea.
That's a good one.
And depending on my ability to actually write it, I may try to put out a video dealing with a live stream I tried to deal with earlier today about this cop out of Massachusetts who was just indicted by the feds, who did some very unpleasant things. So yeah.
Oh, all right, cool. Well, before I get out of here, I got to thank Linda, Simos, and Christina Ray. Thank you guys always, my super mods. You guys are here for the long haul, and I really, really appreciate you guys being here. So, just as a recap, we went over April's motion to dismiss. She's being charged with more crimes. I do have a new Dalton video coming out. The police chief lost his license to be a law enforcement officer.
Nice.
So that means that now he can't even do any arrests or be a law enforcement officer because you got to be licensed. So that's going to be fun. And we're gonna, I'll continue to follow the Nick stuff. I'm thinking I'm gonna do just an independent video, just clarifying, like, hey, these are the issues with Nick's argument, because I think some of these arguments, they look good on paper because like even my video, I just wanted to just take Nick's arguments and give them fair hearing and say this is what he's arguing. But I think when you compare his arguments to the documents, it all breaks down, because here he's saying the cop just saw a clip and the video wasn't removed, but then the cop says, hey, I did see the full video and here are the points. So I think that's going to make Nick's arguments even worse. But we'll see. But I am hoping that he wins though. And I'm hoping that he gets help, because I think those are the two best things that can happen. But with that being said, don't forget, like, share, subscribe, do all the great YouTube stuff, and we will see you next time. We have Dalton next week. I think it's Dalton's again. So next week, the first Monday of the month, we watch the Dalton Madness go down. So we're going to be watching that the first Sunday.
I'm going to check out Joe's stream
election
now.
time.
That'll be fun.
Oh yeah, and I'll go check. Oh yeah, and you'll be redirected to Joe's stream, and after I end this one. So with all that said, I will see you next time.
Bye.
Peace. And stream.